Oh, God. Hey, we get lots of and this time.
Sure.
What was it? Karen, do you have the Wi-Fi password? I have my phone off, but this thing takes alerts. Monitor. Sorry, I didn't know. I have it turned off, but it's gonna keep going off because it can't. All right, thank you. Sorry about the delay. I want to welcome everybody to tonight's September 12th Graham City Council meeting. I'd like for Joey, do you mind doing the invocation?
I can. Our gracious Heavenly Father, we humbly come before you and ask for your wisdom tonight to make the decisions of the city and just be with all of us and keep us all safe and in Jesus' name we pray, amen.
Y'all stand for the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
We will now move on to the consent agenda. These are items typically non-controversial. Please let me know if you have any questions. Item A, to approve the August 8th, 2023 City Council meeting minutes. B, to approve a request for the Alamance Community College Ren Hartson 5K Run Walk event on November 4th, 2023 from 7 a.m. to 10 a.m. and to close a portion of Jimmy Kerr Road and Cherry Lane pending NC Department of Transportation approval. To set a date of public hearing for October 10th, 2023 to consider a contiguous annexation request extending the corporate limits to the city of Graham for a tract of land totaling 18.132 acres located off Longdale Drive and to direct the city clerk to investigate the sufficiency of the petition. D, to approve a budget amendment to increase the federal drug monies budget in the amount of $30,000 for professional services.
Madam Mayor, I make a motion that we approve it as read.
Question that I have is, Megan, what is the professional services?
I will let our Assistant Chief Rodney King give as much detail as council would prefer. It is essentially for Tofano is their consultant who does a lot of their training and helps with their releases and social media. It's a standing contract that they've had for a number of years. And it's not paid for by tax dollars. It's paid for from the federal drug money.
Good evening, Madam Mayor, City Council, Manager Garner. The staff report that was submitted was for payment of a contract for our training and development for our critical incident messaging development. It's also related to our succession planning necessary to develop the skills necessary to take over the positions of the public information officer and to communicate clearly with the public the messages from the police department.
The public information officer?
Yes, our public information officer is being trained and developed to, message with the public, what's necessary that to meet with the media. And
So this is their training
yes,
budget. Okay.
right.
Anybody else have any questions?
No, ma'am.
Do I hear a second?
Second.
All in favor?
Aye.
All opposed? Motion carries. Public hearing. Annexation 67.441 acres, Kimry Road. A public hearing has been scheduled to consider an annexation ordinance to extend the corporate limits to the city of Graham for a tract of land totaling 67.441 acres located off Kimry Road. I recognize our Assistant City Manager, Aaron Holland, for this.
Thank you, Mayor. And this probably looks pretty familiar because we recently did this annexation, I think last month. The issue that we did find was that the meets and bounds that were provided by the surveyor included a portion of property which wasn't meant to be annexed in. So the process of y'all taking that off last time allows us to bring this back this month to properly approve the annexation for the right amount that's supposed to go through. So what you have before you is actual meets and bounds that should have been approved in the annexation the last time.
Okay. This is a public hearing. If anyone is here to speak on the proposed annexation, if you'll please come to the front so we can recognize you and state your name and your address for the record. Seeing no one, I need a motion and a second to close the public hearing.
Madam Mayor, I make a motion that we close the public hearing at this time.
Do I hear a second?
I'll second.
All in favor?
Aye.
All opposed, motion carries. Now we need a motion and a second to approve or deny the annexation ordinance.
Madam Mayor, I make a motion that we approve the annexation ordinance to extend the corporate limits of the city of Graham, North Carolina for 67.441 acres off Kimry Road.
Do I hear a second?
Second it.
All in favor?
Aye.
All opposed? None. Hearing none, motion carries. New business. Demonstration ordinance, chapter 20, article 6, section 20.171 -184, parade demonstrations and street events. The city council will consider a code of ordinance amendment of chapter 20, article 6, section 20-171-184, parade demonstrations and street events. I'm going to recognize our Assistant City Manager, Aaron Holland, for an update on this.
All right, thank you, Mayor. The parade and demonstration ordinance has gone through several amendments over the past few years. Following the adoption of the current ordinance, it was determined that further legal review of this ordinance in conjunction with the League of Municipalities was needed. Tonight, we have Christian Ferlin with Hall Booth Smith LLC, who has worked with staff to prepare a revised ordinance that will update the language and streamline the process. As discussed further in the ordinance, the purpose of this amendment is to ensure the safe passage of public right-of-ways and safe and unimpaired enjoyment of public places while encouraging the exercise of the rights to free speech and assembly within the city. You're not going to be voting to approve the ordinance tonight. We would have to have another meeting where we would have it on the agenda for you to move forward with it. But this is to introduce the language to you tonight, and Christian would be the one to do so.
Right, we welcome Christian. If you'll come forward, we appreciate you taking the time to help us with this ordinance.
Thank you all, Madam Mayor, City Council. Thank you all for being here tonight. Thank you for having me. As Aaron mentioned, my name is Christian Ferlin. I'm an attorney in Charlotte. I work with the North Carolina League of Municipalities and the city of Graham in some litigation. And I've undertaken the task primarily of helping to work with what was Graham's prior protest or demonstration ordinance to revise it and kind of put it in a workable state where you all can implement it hopefully at the next city council meeting. I believe you all have been provided a copy of the ordinance. If not, I have copies here. Does anybody need?
Can I have a copy?
Yes,
I
ma'am.
don't have, I prefer to look at a hard copy.
I have 10 copies of that.
Thank you.
Words. There was a copy of the ordinance circulated, I think, last week or 2 weeks ago by Megan Garner. I'd like to point out that there were sections of the ordinance, or the prior ordinance, I'm sorry, I shouldn't be referring to it as the ordinance. There were sections of it that we did not feel the need to revise or look at all, because they were addressed in other sections, and that caused a slight oversight in transcribing and re-including one of the prior sections. That would be section 20-177. I've included in the copy that I've sent to you, and I sent Megan a clean copy of the complete ordinance earlier today. That section was mistakenly omitted, but it remains unchanged compared to the prior version. So what I think the best way to do this is to just go through the ordinance section by section, starting at section 20-171. I'm happy to field questions as if this were a hot bench in court. That's what I'm comfortable with. If you all are comfortable with that. If not, I can ask for questions after reviewing the changes of each section. Section 20-171, the primary revision here is the addition of a purpose statement. And the purpose statement doesn't substantively change the ordinance. However, it clarifies for both the public and anybody looking at this ordinance that the city's purpose in enacting it is to enact a content neutral time, place, and manner restriction on public gatherings, essentially, and within the city of Graham, based on our consultation with the chief of police, the fire chief, and obviously a pretty intense review of case law. So you'll see that section 20-171, subparagraph A says, pursuant to the authority granted to the city of Graham by the general statutes of North Carolina and its general police powers, the city has adopted the following sections in order to provide for the public health, safety, and general welfare in the city, to ensure the free and safe passage of pedestrians and vehicles on the public rights of way, and to ensure the safe and unimpaired use and enjoyment of public property in places open to the general public, and otherwise to regulate and control the time, place, and manner of the activities that would otherwise threaten or impair the public health, safety, and welfare in the city, while also encouraging the exercise of the rights to free speech and assembly in the city. This theme comes up frequently in the text and some of the revisions that we made. I firmly believe that the prior ordinance could have had this section in there, and it would have read all the same, and you could make the same connections. But I think we've cleaned some things up and made the ordinance more understandable for the public and a little bit easier to administer for the city. So again, what we're looking for here is a content neutral time, place, and manner restriction, and the city's interest in making those restrictions essentially is the public health, safety, and general welfare in the city, and to ensure the free and safe passage of pedestrian and vehicular traffic. Are there any questions about subsection or section 20-171?
Who would be the designee, I guess, point of contact? Megan, do you have an idea of who that designee would be?
Referring to subsection B?
Yes.
That would be, this was previously written for the Special Events Committee. I assume the Special Events Committee is still in force. I'll defer to Megan on that. I think we talked a little bit about how that's going to work kind of on the back end of things.
Yeah, so the Special Events Committee doesn't serve in the exact same function as it served probably a year and a half or so ago, but they do still serve as a vetting process before any road closures come before City Council. So it's made up of various individuals, Aaron, the police department, fire department, public works, and probably some others. And they ensure compliance with different parts of our ordinances, and insurance requirements and other things before a road closure comes to city council for consideration.
I guess, I still have the same concerns that I had, previously. If I decide, for instance, that I want to close down Main Street and I want to come get a permit and I want to close it down because my husband's having a birthday party. And I'm going to inconvenience every one of those businesses on that road because they're not going to have access to their business. I'm going to do that. And within 4 days, that event's going to happen. How is that fair? I don't agree with any of that. And they have no representation. They're clearly a stakeholder. And, I just don't, there's kind of you're not trying to prevent anybody from being able to, do whatever they want, but there's a more appropriate place to have a birthday party than it is to deny access to roads. And even when we are not in any way considering the content of the event, whether it's a protest, whether it's a birthday party, whether it's a parade, whether, whatever it is, that's not always sometimes seen as that. Well, you just don't want them to be able to do that. No, we wouldn't do that for somebody wanting to do a birthday party. We wouldn't do that for someone. And it leaves the business owners, I think, in a difficult situation because when you have a number of events, I mean, I think maybe pre-COVID, I think I counted, there were 27 weekends that they were going to close down the road. And for a business that has, on a Saturday, they don't like that. They don't want to have restrictions to their business closed down. So
Yes, ma'am.
how do we navigate that?
Understood. I would direct you, we're getting ahead of ourselves, but I'm happy to jump around and address issues as they come up. I direct you to section 20-183, specifically paragraph C2 and C6. These are the road closure permit considerations for the city council. As well, I'll assume that none of you have looked at this or discussed it with an attorney, which would make sense because that's why I'm here. But what we've basically created here is a concise and direct and objective set of factors that the city council can look at to decide whether a road closure permit can be issued or not. And subparagraph 2 would, C2 would be the location of the event and whether closing the roads requested materially inhibits the flow of traffic and threatens public safety based on traffic counts of the roads sought to be closed. That I think would address some of your concerns about Main Street with the traffic counts on that road versus, I'm not terribly familiar with Graham, so I'll say something like Elm Street that I know is further, or some sections of Elm Street are further away. And a little bit more residential, where closing the road wouldn't inhibit so many businesses' activities. And I would,
Could you give me that reference again where you're?
yes, ma'am, 20-183. And then C2, and then I'm getting right to C6. I hope you all have the same copy that I do because I printed it out today. Okay.
Mayor, what was your reference to 4 days? I didn't understand where that came from.
I believe there's this part in here that says that within 4 days, a permit they'll act on a permit request within 4 days. Is that correct?
Yes, ma'am. I'll get into the timing of this. I'd like to discuss kind of the substance of it, and then we can get into the timing and turnaround times and review times and things like that. But subparagraph 2 is addressing your concern regarding traffic counts and closing down a major street for, let's say, me and my 99 closest friends to celebrate my whatever birthday is coming up. And then subparagraph 6 is whether the event would be likely to adversely disrupt or interfere with the rights of owners or occupiers of property abutting those portions of the street sought to be closed, or having a right of ingress and egress from their own property to the portions of the street sought to be closed. I think that that section, I don't know if it adequately addresses, I can't speak for you, but I think that section is addressing the concern that business owners could lose business, or they lose the right to ingress and egress to their property, and the rights of free speech certainly are extremely important and things that the city wants to defend. But they're, the time, place, and manner of that speech should be regulated, and the rights of the speakers have to be to some extent counterbalanced against the right of property owners and others in the area. And I can say confidently.
and we
the
do
cases are
that.
similar to that.
We do that consistently, I think, when we're looking at doing festivals and things. We look at, well, okay, on Saturday, this particular part of the street doesn't have any businesses that are open on Saturday. So this is obviously a much more less disruptive place to have that event than say on the east side that all the businesses are open on Saturday. So we just want to apply the law consistently.
Right, and that's what this list of factors is meant to do, is the courts call them a list of objective factors. Basically, you look at facts that aren't really subject to dispute. A traffic count on a road is somewhat variable, but it's not really disputable. And if that traffic count would be a threat to public safety, or disrupting that traffic count would be a threat to public safety, either on other roads or just by virtue of having that road closed for emergency vehicles getting through, for example. That weighs into the city council's decision to grant or deny a permit.
So in one section, it talks about based on whether you're going to have a certain number of people. Is that correct?
Yes, ma'am.
Okay, I'm sorry, I read this, but I'm. I
that's
think it's,
fine.
Section 20-179, right?
Yes, ma'am.
Okay. I do a lot of events myself, so I can tell you that it's a real difficult decision for someone that has never done an event to know how many people are going to be there.
Right.
So how do we navigate that when people think, oh, well, there's going to be 1,000 people there, but only 100 people show up? Or they say, oh, I think we're only going to be 50 people, and then 1,000 people show up.
So that's on the person applying for the permit. Once you hit that 100-person threshold, you're obligated to a 100-person threshold convened for a common purpose. So you meet the definition of a demonstration. You're obligated to go get a permit. Now, if somebody says subjectively only 99 people are going to show up and then 5,000 people show up, then we're dealing with probably an unlawful assembly. I can't say that's a full hypothetical and I can play that out. But that's kind of the direction that goes. And then you find your event organizer, and at that point you're aware that person has either materially misrepresented or intentionally, well, I can't say that for sure, I'm sorry. There is a possibility that person could be believed to have materially misrepresented or intentionally disclosed information for the purpose of trying to get around the law. There are a lot of other factors that go into it, so I shouldn't be speaking in absolutes, but essentially the 100-person threshold triggers a permit requirement. Street closure aside, street closure is the city council's decision. But at 100 people in the fire limits of downtown Graham or 75 people outside the fire limits of downtown Graham, that person's obligated to go get a demonstration permit.
So in real world application, someone has applied for a permit. 1,000 people show up. Not supposed to be blocking the streets, not supposed to be blocking the roadways. Roadways have not been closed. There are children there. There's 25,000 cars coming through. What should the police department do under this ordinance?
Yes, ma'am. That is 20-181 subsection B. Whenever the free passage of any street or sidewalk in the city shall be unreasonably obstructed by a crowd, whether or not the crowd assembles as a result of or in connection with demonstrating, the persons composing such crowd shall disperse, move, or move on so the street or sidewalk is no longer obstructed when directed to do so by a police officer. Shall be unlawful for any person to refuse to so disperse, move, or move on when directed to do so by a police officer. So the 100-person threshold was something that was discussed at length with Chief Cole and the fire chief, whose name escapes me right now. I apologize.
Chief Cole.
Chief Cole, got it. Chief Baker and Chief Cole, I apologize. Okay, well, it's Chief Baker now. Again, I'm
We keep
going
it
back into
on.
my old habits, but anyways, that's what this section is meant to address. In the past, or you can probably envision a scenario where you have a group of 200 people that's kind of milling around, and some people are spilling over into the street. This subsection B has actually been amended from what was the prior version to have officers instruct people to clear the road or clear the sidewalk so they don't block vehicular traffic. And that gets back to the purpose of the ordinance in 20-171. So instead of, the second a demonstrator steps into the street, you break it up. The instruction is just to stop blocking the street or stop blocking the sidewalk, which is the entire purpose of the ordinance to begin with.
So is it lawful then for the officers to then, at request, because there was no permit, gotten, and more than 100 people showed up, and they were like, let's say in the scenario, like if it's 1 or 2 people over 100, I'm sure it's not a problem, but if it's like 1,000 people and they're blocking the roadways and all that sort of stuff, is it appropriate for them to disband the demonstration or parade or whatever it is, and then say you're going to have to apply for a permit in order to be able to, and then, you've got to have things like barriers out, detour signs out, all that in order to ensure public safety? Is that like what we think the police would be doing?
That's essentially it. I can't say for sure as a lawyer. I'm playing through all of the scenarios in my head and trying not to, pin down any one scenario, because again, there's so many components that go into it. The group has to meet the qualifications for a demonstration. If there's 1,000 people sitting silently, they're still crossing that 100-person threshold, but they might not be causing a huge public disturbance, but that's just kind of the reality of the law. The short answer to your question is probably yes. We want we want these large groups to register just because it creates a public safety risk. Especially, if we're talking about 1,000 people, you can't hope to have 1,000 people walking 2 by 2 around on sidewalks. And certainly you want the police to be there to make sure that cars aren't hitting those people if they're trying to cross a crosswalk.
Right.
So the short answer is yes.
Okay. And is there anything in the ordinance to protect children at these events?
So having attendees under the age of 18 is an automatic trigger for a permit requirement, which puts the police department in the city on notice that children might be attending. And that's the purpose of the permit really. It's twofold. It's to make sure that the city has adequate staff to make sure that everybody in the demonstration is kept safe, and also to protect the public at large. And when the police department finds out that children are going to be involved, their ears perk up, and they'll employ staff appropriately. It could be a demonstration of 11 people, but you're going to have 5 children there. Technically, that triggers the permit requirement if we're talking about a demonstration. And that's yes, the police will have notice of it so they can adequately protect the children who are in attendance.
Okay. You brought up the issue of paying for staff. In a normal situation, when someone does an event and it's a quite large event, and police are considered by the event committee to be necessary, that event organizer has to pay for police through an organization called EDS, Extra Duty Solutions. And they're, I don't know, $30, $40 an hour, something like that, $30 to $40 an hour. How does that work in relation to this? Is anyone that is going to have a demonstration or parade or whatever, are they requiring that?
So the payment provisions or the city's payment arrangement, whether it's for police department, EMS, porta-johns, road barriers or anything like that, was not addressed in the prior ordinance. And it's not addressed in the new ordinance. I'd be happy to go back and look at that, but it wasn't part of the city's prior scheme. So I didn't think it was appropriate for me to write it in, unilaterally and present it to you and tell you what your business, the business end of things should look like for you. However, if given some parameters, I'd be happy to look into that. But it is not reflected in this. So essentially that means whatever system is in place right now continues to be in place.
And, so in regard to the 4-day notice or the 4-day determination, it's really hard to do things in 4 days.
Yep.
For an event that could be 1,000 or 2,000 people even. You don't have staffing, you can hardly get people to bring porta-johns, any of those things. Is there any room around that 4-day rule? It's not trying to keep anybody from doing anything, but it's just really difficult to kind of have a special events committee meet, go through all of the rules and requirements for the venue. So like if they're doing it, say at the historic courthouse, there can't be any like gas powered equipment, that sort of thing, due to being in the B1 district, those kind of things. Going through all of that and then being able to turn that around in 4 days is almost, it's a real strain.
Right.
Staff might be on vacation, all these kind of factors come into it.
So the 7-day requirement is a product of case law. There's the courts have said throughout the country, first through 11th Circuit, DC Circuit, Supreme Court. There's no magic number for what that advance notice requirement is. It just has to be reasonable and can't unduly burden speech. That's what the 7-day advance notice requirement is meant to get at. The 3-day turnaround is to ensure that all of the permits, again, these are inner limits. The outer limits, we could set it at up to a year to have your street event planned. The inner limit of that 3-day turnaround is to ensure that the applicant can then, if we're following, the letter of the law, can then go to the police department and get their demonstration permit, which is required 72 hours advance notice. That's what those turnaround times are meant to reflect. What the city council looks at during, and I think this is where you were going with it, with the resources required to kind of support these events. But again, go back to 20-183 subsection C and then subparagraph 4. Whether the level of public resources required to support the event have been or reasonably will be secured by the event organizer prior to the start of the event based on size, time, and location of the event. So if I'm coming to you 7 days in advance and I'm having 10,000 people in downtown Graham and I haven't talked to anybody other than you, I just want to make sure my road's getting closed. In that hypothetical scenario where I'm the applicant, you probably have grounds to deny it because I don't have the resources in place to support that group of people. And at that point, my event is unpermitted or my street closure is unpermitted. I can still go for a demonstration permit, I suppose, but the street will not be closed. The 3-day turnaround time, let me back up. That's a product of the 7-day advance notice window, which again, the cases are inconsistent. 20 days has been deemed too long for certain things, but street closure is kind of another issue compared to a pure demonstration permit. 7 days was selected as a reasonably short period of time that we think could be defended essentially if questioned.
Did it say 7 day? Okay, it does.
Yeah, 7 days, 7 days in advance. And then I believe the decision must be returned within 3 days. We could look at that language and see if the permit application is submitted earlier, 14 or 30 or 60 days in advance, giving the city council a little bit more time depending on the size of the event. But ultimately, the onus is on the applicant at that point, if they're asking to close a street, to tell the city, I have all the resources in place. So at that point, it's objective criteria for the city council. They're looking at what should be a rubber stamp because the person has their ducks in a row, so to speak.
And is it 7 business days or 7 days?
It's 7 calendar days. Again, the cases are, there are cases where they've struck down. This wouldn't be applicable here. There's a Ninth Circuit case where they struck down a 1 day or 1 business day advance notice requirement, but there's a lot of other factors that go into why that was struck down. But the concern is just that you create too short of a period and you unduly burden speech. And I think the 7-day period that we've proposed here adequately protects that interest while giving the city council its requested authority over closing the streets.
But if you did it on a Friday and on Monday, you could, Friday, Saturday, Sunday, Monday,
Yes,
you'd have to give an answer.
yes.
How's that even legal? We have to, even if we were to have a meeting, we have public notice laws to even put in the paper to say that we're gonna have a meeting about a road closure. How do we even do that
That's.
and still meet that burden?
So I understand that the cases have not treated that with any kind of deference, either the difficulty of getting the city council together for a meeting more than every, say, 2 weeks. There have been cases that have struck down permit requirements that have set that 2-week outer limit. And that's, it's just kind of a reality of doing business. Again, the information is supposed to be in the application. And that should make it easy to review, but I understand the city's procedural requirements of reviewing these things. I'm using vague terms. Essentially, if the city council is going to maintain control over closing the streets as it wants to do and as it has the right to do, then it has to fall under the rules set by the First Amendment and the relevant jurisprudence. And the city council could delegate its authority to the Special Events Committee or some other subcommittee that can meet on shorter notice. But as written, with the city council having control over the road closures, that's just how the scheme has to be written, in my opinion.
Madam Mayor.
I'll give you an opportunity to speak in a minute, but, I read this and, I'm sorry I'm asking you some questions, but we
Please do.
we had, 48 protests in 52 weeks, and this is a real situation that we need to know how it's actually going to work. Okay, because there's a lot of moving parts. Can you explain about the amplification, the noise amplification?
Yes, the noise amplification is 20-184. Regardless of group size, basically, if you are going to use noise amplification devices in public that are audible at 60 decibels, 50 feet away, which is the volume of a normal conversation, so clearly audible 50 feet away from the speaker, you need a sound permit. It was effectively a sound permit. And that is part of the demonstration permit application, but it's technically a separate permit. So if I just wanted to go play music downtown for, let's say it was for First Amendment purposes, I would submit an application for that sound permit to Chief Baker, and she could approve or deny it based on the objective criteria given to her. The sound permit application it's something that's well litigated. The statute or the ordinance that we have here essentially reflects the exact language of the case law on this issue, both in terms of volume, notice, and requiring a permit for sound amplification.
So and that's going to cover whether somebody has I don't know, what do you call it, blowhorn,
A bullhorn or a
bullhorn,
bullhorn or an air horn, either way.
or they actually have speakers set up, with a mic and an amplifier.
Anything that amplifies sound. So I guess I
Okay.
misspoke. An air horn probably wouldn't apply because it's not amplifying sound. It's just creating loud sound.
Okay.
But yes,
So clean up after the events. Like when we're planning an event and you have 1,000 people, we obviously have barriers for traffic control. And, you know, we try to make sure that we have children areas where children can't walk out into the street. We have kind of barricades and things like that. We have porta johns, I think one for every, I don't know, a minimum, I think of 150 people, you have to have a porta john. And then, trash receptacles and disposal. Is that just all something that we need to put internally into our process for handling event, you know, meeting with event coordinators and stuff?
that's correct. That wasn't part of the prior ordinance scheme. I don't really, we could put it into an ordinance scheme, you know, requiring a certain number of porta johns per however many attendees you have in an event, but it wasn't part of the prior scheme. So I didn't think it was my position really to write it in. I assume you all have policies and procedures internally that people are aware of or can access, whether it's the special events committees, policies and procedures for reviewing events, or otherwise. But yes, that would be an internal matter.
And then, for the person that's responsible, for the event, requiring insurance for the event?
That also was not part of the prior ordinance scheme. That's something that the cases have looked favorably upon it under certain circumstances. And we could write in insurance requirements. It could also be a part of the city's policies and procedures. If that's already in place, and you are comfortable with those, I'd be happy to take a look at them. But that wasn't part of what we were revising or redrafting here.
The biggest thing, I mean, I personally, I don't know how the rest of the council, I'm just one vote, but I do think that adding an insurance requirement in the event that there's a lot of trash, there's a lot of, I don't know, damage or whatever, that person who is in charge of that event is responsible for making sure that that is reimbursed.
Okay, I'll make a note to look into insurance requirements. Some cities have flat fees per attendee or per officer that's showing up or the size of the event. I think insurance is another way that they've gone about that. I'd be happy to look into it and I can see if I can incorporate that in the October follow-up meeting here.
Our
So-
Parks and Recs requirement has written in their application that you have to secure insurance.
That would be sufficient. So again, I didn't look at Parks and Rec. Perhaps I should have, but I think it was kind of outside the scope of what I was asked to do, looking basically at First
I
Amendment.
think
law.
you should take a look at the Parks and
Yeah,
Recs,
Absolutely.
especially in regards to when you're hosting an event out there, the requirement for insurance and porta potties and security and all of that.
And that,
And-
so to answer the mayor's question, that would be sufficient as a policy, replacing, let's say, section 20-183 subparagraph D. Instead of inserting a paragraph D there, your policy with Parks and Rec that is equally accessible. It's not a regulation on speech as far as I'm concerned, as long as it's not.
It's all about the event.
Essentially, yes. Does it have some impact on speech? Yes. Is there certainly a First Amendment aspect to it? Sure. But your policy is probably sufficient. I'd be happy to look at it and compare it to the cases for you.
Right.
Is it allowed to separate different groups that have come to protest on the same day?
Are you saying, well, I guess it doesn't matter, protesters and counter protesters or demonstrators and counter demonstrators, or are we talking, you have a group coming to celebrate my birthday and a group coming to celebrate your birthday?
Correct.
Both. Yeah, there are designated areas. Well, the police chief has the authority to create designated areas for both demonstrators and counter demonstrators or competing demonstrations that want the same area. The permitting scheme that has been written up is essentially first come, first serve, or priority for for first come. Understanding that space for counter demonstrators may need to be considered and considered equitably, whether it doesn't have to be political. Somebody who doesn't like me wants to protest my birthday and I want to have a birthday party. We have to allot an equitable amount of space for those people to come protest me compared to the event that I'm holding. That would be, I'm gonna go search for it. I believe it's 20-179, subsection H, or paragraph H. Any issued demonstration permit may prescribe reasonable requirements or conditions necessary for the control and free movement of pedestrian vehicular traffic, including emergency services, and to protect safety and property rights of participants, including counter demonstrators and of the general public. The city reserves the right and authority to have police officials on scene to further designate, that is, reasonably expand or limit the permitted areas in furtherance of the ordinance as reasonably necessary for public safety.
It doesn't say how big of a difference, but I had read in another ordinance 40 yards. Do you know what the case law is on that?
No, the case law essentially says that the counter speech group has the right to hear and respond to the speaker. So 40 yards, you can use 40 yards as a measuring stick, but this is going to be like the advance notice requirement and the attendance thresholds. There's no magic number. It just has to be audible. And again, when we're dealing with sound amplification or no sound amplification, that also kind of gets implemented or impacted as well.
So what I had read was that it was upheld by the court as 40 yards, but it's if you could look into that to
Sure.
see, only just to make sure that everybody's being treated equally, I
Yeah.
guess.
Yeah, the courts essentially require, and this isn't a perfect answer to your question. I can find cases on point that will have varying degrees, and essentially it has to be reasonable. It has to be narrowly tailored to fit the government's legitimate interest, and the legitimate interest in this case would be protecting the safety and protecting public safety, making sure that the two groups aren't dangerously intermingling, but also protecting the speech rights of both the counter demonstrating and the demonstrating group to hear and speak to the other. So 40 yards could have been reasonable in New York City or in Dallas, North Carolina. It's going to depend on the circumstances, and as long as you don't cross one of those outer thresholds, like a 20-day threshold for advance notice or something like that, you just have to be able to. It has to be a reasonable decision or a calculated decision. But I'll look into it for you.
Okay, and then the free protest area is out here, but in the example of us holding a city council meeting, if they're using amplified sound and we can't hear the business that's going on in here, what is an actionable item that we can do regardless of the fact that we obviously want people to be able to have their free speech, but just like I don't allow someone else here to disrupt the meeting while you're speaking, we want to give them the same opportunity to speak and not allow other people to speak while they're speaking. But while we're conducting business, we want to be respectful of everyone's opportunity to speak, and we're not trying to violate anyone's right to speech. But at the same time, the person that's presenting and it's their time to speak, that you're somewhat violating their right to speak by allowing amplified sound during that time. So how do we make sure that we're following the rules? And
Yes, ma'am. What you're basically referring to is what's referred to in the case law as the heckler's veto. You disagree with somebody, you can't just shout them down, or well, you can just shout them down, but you can't override their right to speak. So the free speech or spontaneous gathering zone that is on, I believe, the lawn of this building, if I'm correct. I've put a tab in my version with my notes to go back and look at that with respect to sound amplification. What we're looking at is a time, place, and manner restriction. Certainly the people outside and inside have an interest in the city council conducting its business, but you've identified the counterbalancing concern that the city council should be able to conduct its business. So I will go back and look at that provision with respect to sound amplification, levels of noise, and the the reasonableness of certain restrictions on the time, place, and manner of that speech in the spontaneous gathering zone. You know, the city's not required to put one up. But I think it's a good idea because it's a guaranteed alternative channel of communication, which is another thing that's looked upon favorably by the cases. So putting some reasonable restrictions on the use of that space, I think would be worthwhile.
I'd like to go back to the issue of the day, number of days. Where you mentioned the applicant can file, no less than 7 days. And then the permit has to be issued no less than 4 days before the event. But then you go back to the appeals process, and if an application is denied, the applicant has 7 or rather 5 business days.
You're right, there's a conflict there,
Yeah.
and it's unavoidable because we can either extend the period to an unreasonably long time,
Well,
or
I could,
or take away the right to an appeal, which is an equally problematic.
well, if we're gonna say 5 business
Yeah.
days there, why not say 7 business days? Likewise,
For both,
yeah,
you could, and that.
I mean, that's not unreasonable. Because it brings up the matter, as the mayor mentioned. If you got to reply back within 4 days and you're smart and you figured out they got Friday, Saturday, Sunday, and Monday. And so,
Comes in at 4:49 on Friday. I mean, we just have to make sure that we are writing these ordinances so that we don't have a misstep and that we're
Able to follow your own procedures.
well, it gets sticky because if someone's out, I mean, if you can't get all the people from the event committee together and somebody misses something, and I mean, safety has to be our paramount consideration, in my opinion. The safety of children is very important to everyone that sits on this dais. The safety of the participants, where I have seen things go really, really badly, it seemed that people didn't think, about what could have happened, and we really have to think through what the outcomes could be in order to make sure that everybody participating in these events are safe. So you've got situations where people didn't get a street closure, but you've got people at the event saying, stand in the street, on a megaphone. You can't reconcile them there. And the person that's standing in the street has the assumption that the road's supposed to be closed, but they weren't the organizer. And so they have no knowledge of that. And, when you're trying to organize a lot of people, even when you have the best of intentions, we just don't want anyone to get hurt. We
Right.
don't want the officers to get hurt. We don't want the demonstrators or the parade participants or anyone. And to try to rush things through, it makes you very nervous that things sometimes are not communicated to all. And that's what we have to make sure that we're trying our very level best to do.
You're absolutely right. And the issue with the 7-day turnaround time is just the constitutional law associated with this issue. The city has to enact a constitutional ordinance, otherwise it won't be enforceable at all. It'll just get struck down, and then
Right.
there will be nothing in place, and you can try again. And we go through the same process, and eventually you can probably strike a proper balance. And I'm not saying that that's what we're going to be going through here. I think this statute or this ordinance is defensible and would be upheld by what I think would be any court. So the more we expand or limit or change the provisions herein, it creates certain risks, and whether those risks are, I don't think that they all create a risk that the statutes or the ordinance is going to get struck down, but it's kind of just a balancing game where you don't have strict guidelines from the Supreme Court telling you exactly what you need to do. Certainly the 7-day turnaround time is short, and the 4-day response window is difficult to meet.
are those two numbers chiseled in stone?
We can
Could
change
we
them.
say not less than 10 days, but no more than 365 days? So we're sticking with calendar days, and then change no later than 4 days. You know, can that be increased to no later than 6 days before the event?
Sure.
You know,
I can't say that what I wrote here was basically what I think would be strongly defensible if somebody were to just, without anything happening, challenge the ordinance on its face.
but I guess as I think about it now, the 4 days before the event,
That's to ensure that there's no pocket veto by
Right.
the city council, so the person can go out and
Yeah.
get their demonstration permit as well.
Right.
Because the street closure permit has to be received before the demonstration permit. Now, you know, if we're talking about somebody who's submitting on that 7th day and you have until that 4th day to return it, you know, they better have a rock solid event planned with everything in place. All they need is for you to say go on street closure. That's what that represents. If they don't have their ducks in a row and they haven't completed, haven't given you a complete application under 20-183, then
Mhm.
that person's not prepared to have their event and the permit's denied,
Right.
in theory.
Could they, what, so you're saying if they don't have a completed permit?
I'm not saying this is an absolute. I'm saying if somebody is towing that line, let's say I'm applying for a permit and I'm towing that line, applying exactly 7 days before my event, which is all I'm required to do. I have to have everything in order for the city council to say this event is good to go. You've met these six objective factors, and you're prepared to go forward with the street closure component of your event, and then you can go apply for your demonstration permit if you haven't already, but you need the street closure before you get the demonstration, if you want the street closed for the demonstration. So yes, you'd be dealing with somebody either who has all of their ducks in a row or they don't. And if these 6 objective factors are not met, then they're not entitled to a permit. The problem I think that we're all kind of playing with right now is what that turnaround time is. Certainly the Friday to Monday turnaround is difficult. We could write in an extra day there, but then we're playing up against that 72-hour window to get the demonstration permit as well. If you have somebody who applies 7 days in advance and you want to give the city council an extra day, the city council could issue its decision exactly 72 hours before the event. And in theory, that person can't go ask for a demonstration permit.
Is it possible to put something in for 4 days to approve unless it falls on a
Sure,
weekend? I mean, that would eliminate the
sure.
problem of nobody being here on a weekend.
It's possible to do all of this, and
But still leave it at that to keep the speech, the free speech.
So to give you an example, DOT, how long does it take to get DOT to do a road closure? So this Main Street.
Yep,
Again,
road.
people not understanding. They ask for a road closure. They don't understand, what the road count is. You know, and my argument is, if you want to close down Main Street and you're going to affect all these businesses with 4-day notice, like from a Friday to a Monday, even with a 3-day notice, like I can tell you that is really gonna be difficult. Those businesses are not gonna be happy about that at all. And when that same demonstration could be held as an alternate 1 street over, like just go 1 street over, it's not gonna affect any businesses. It's not gonna affect traffic flow of 25,000 cars, that sort of thing. That's where we want to I guess, be able to dictate that. And then, like, again, DOT, somebody will go to DOT, get a road closure, and then they think they have permission to do the event, not knowing that they have to come to the city of Graham and also get that. So sometimes one hand doesn't know what the other hand is doing. The same thing has happened with the county as well, where they've gone to get a permit from the county to use the courthouse. property around the courthouse, they give them a permit, they think they have a permit. It's like, no, that is a county building inside the city limits of Graham, and you still have to come get a city permit in order to be able to do that. And obviously, they might think, oh, well, you're just trying to keep me from being able to, no one's trying to keep you from anything.
Right.
But we have a process. And my argument to the county was you need to have somewhere on their application that clearly says you need to obtain a permit from such and such. If you're going to be in the roadway, you need to obtain a permit from DOT. I doubt DOT does anything in 3 days, certainly not from a Friday to a Monday. So I don't even know how we would even turn that around. And it's great to have stuff, there's stuff in ordinances all the time, but then when you like put it into real world application, it's so difficult.
Sure.
So I hate that it seems like, but we've,
No, I understand the real world implications are kind of, well, they're beyond my experience and expertise as an attorney. The components with the county and the DOT, part of that should be cured by what I think is a more understandable and straightforward ordinance. We took out the notice of intent to protest provisions. We've made it very clear when you need a permit, when you don't need a permit. The requirements are all pretty easy to understand. And they apply regardless of where you are in the city, unless you're on county property. So I think the city is doing all it can by, in my opinion, enacting this ordinance or enacting something like this ordinance. And if people don't understand where the county comes in or where DOT comes in, there's only so much the city can do to, you can't
Can
write
we
an
not-
ordinance to regulate the county and DOT.
Yeah, but could we not write in the instruction, a decision tree? Are you going to require closing a state road? Yes or no? Yeah.
Sure.
Is your demonstration on county property versus city property? Yes or no?
You absolutely can. And I think the reason we haven't is just that person wouldn't be looking to the city's law to determine when they go to the county and when they go to DOT, because in the hypothetical that was posed, they've already gone to DOT and they think that's sufficient. So they're not looking elsewhere. And now I don't know how many people that applies to, but that's the hypothetical scenario that was posed. And I can't write an ordinance to teach those people to look at the ordinance. They have to follow
We're
it.
not asking
Yeah.
them to look to the ordinance,
Yeah.
but it's just a question. Are you proposing to close a street that's a state
Yeah.
or county road?
So one of the things that I originally did when we were rewriting this was writing a kind of a user guide or a pamphlet that could be handed out. I think, again, my response to that hypothetical, that would be something that could be included in it. The issue is that there's kind of a selection bias there where the people who are looking at that know that they have to follow the city ordinance. And then they're asking themselves those questions of, okay, where do I go? So that would absolutely be a useful tool to tell people, hey, you might have to look somewhere else. But for the city's purposes, those people if the city's handing it out, those people are already looking to the city for guidance and authority to do or permission to do what they're seeking to do. Does that make sense?
I almost think that maybe when someone goes to the county or DOT, that they need to then refer them back to us and us have the county's application and the DOT's application or something like, so that I don't want, and it's happened. I mean, people go to the DOT, they get their permit and then they think they're done. Same thing with the county, and just one hand doesn't know what the other hand's doing. And so that's a little bit frustrating. And the other situation is, well, I'll bring that up in a minute, but go ahead, Aaron.
The DOT has changed how they issue or they're looking to the city to see whether that can approve to the city or not for the issue. So say especially events like the 5K, for example, which involves pictures and DOT road. Got past it tonight. I'm sending an email first thing in the morning to letting them know that that there will be a 5K on so-and-so road. It's the application, city council approved it at their meeting on so-and-so date. And then from that point, they run it through their stuff and then they issue approval. So they're looking to us now to make sure that we're good before they approve anything on their end.
Okay, we just, I think, need to have that same arrangement with the county and a situation being like, and this is what I want to bring up. So you have a bridal party. These brides, they've planned a year in advance, since the time they were little girls, they've, look forward to doing this. They're going to have their pictures and everything done downtown with the murals and all of that sort of thing. And they've kind of reserved a space there. And then the county gets a permit request to have that, in that area. I mean, you can obviously see that she's going to be upset if and maybe so if the venue is already booked, if a venue is already booked in one person's name, but then someone wants to come and book it for some other event or whatever, is there a way to be able to provide legally an alternate venue rather than, say, a courthouse?
I don't know if I'm following the hypothetical. The bridal party wouldn't need a permit unless they want to reserve space, which would more be a probably Parks and Rec.
So
type.
we have like the Sesquicentennial Park there. So they were taking pictures there in the park. They were taking pictures in front of the mural. They were taking pictures in front of the courthouse. They reserved that ahead of time. And then someone else wants to use that on that specific day, but it's already reserved by someone. Does that reservation, that first reservation, allow to say, no, you can't use that spot because it's already reserved for someone?
Yeah, just like you could reserve the middle school gym for an event. Yes. That group presumably wouldn't need a permit, but reserving the space is separate from needing a permit.
Okay,
If they want to protect that space for themselves.
okay. All right, and then, can you direct me and just walk me through the process of someone has applied for a permit and it's a 5K race, it's whatever, it's a demonstration, and they've decided that they need to have police there in order to be able to do traffic control, whatever. But there's not enough police staffed, especially with a small window. Is the option then to give that applicant EDS, or to just say you can either do EDS, and if you can get EDS to agree to have enough officers there, if not, then the permit will be denied? Is that a reasonable reason to deny the permit because you don't have staff to staff it?
Yes, that would be 20-183 C6. Sorry, not C6, C4. The level of public resources available. There's the extra duty service option. It's a little bit different. You brought up 5K or what could be a street event and a demonstration. Those things are, I think, I may be getting over my skis here, treated a little bit differently by the police department in terms of calling in mutual aid versus requiring extra duty service. I candidly am not terribly informed on that or not terribly well informed on that because it's an internal matter for how the police department deals with other police departments, both extra duty service and calling in mutual aid. The answer to your question is that it falls under subsection 4, so they need to have those public resources available. So if you're applying 7 days in advance for a road race, which you're allowed to do, and you don't have your ducks in a row to go seek that permit and say, I've talked to Burlington, I've talked to Alamance County Sheriffs, I've talked to Graham PD about this, and pending my demonstration permit to have the gathering, I have the resources in place and I'm prepared to pay for them or, you know, otherwise employ the officers or protection that I need, whether EMS, police, whatever it may be. They basically have to have that ready to go if they want to work on that short timeline. And they're also running the risk that those roads are already closed.
Okay. And so as long as we are applying that requirement across the board,
All of this is applied. These are, again, I describe them as objective factors. And what that means is that you're not looking at the content of the speech and you're not looking at your subjective views of the individual. Whether you like them or don't like them in approving or denying the permit. You can certainly look at your experience with them. That's one of the things that Chief Baker looks at when dealing with a demonstration permit. Let's say somebody's lied to her 10 times about how many people are going to attend the demonstration. And they're saying this time it's going to be 101. And she knows I've dealt with this person before. They've made material misrepresentations to me. That's one of the objective factors that she can look at to deny a demonstration permit. They're all listed out, so they're clear to the public. They're concise, they're direct, they're easily understandable. There's actually, let me pull the language before I put my foot in my mouth with the wrong word. Reasonably specific and objective, and do not leave the decision to the whim of the administrator. Now, we believe that the administrator or decision makers decisions before were sufficiently guided by objective factors. It certainly wasn't a completely discretionary decision, but we've now kind of enumerated what they're allowed to look at and either deny a permit based on those bases if they exist, and if they don't exist, then the permit gets approved.
where's the section about? Because there was a section, it was in 174, I believe. Okay, special events committee shall approve no route which is going to the preservation of. So we had specifically said like for routes that are over 10,000 cars a day, we deem that consider to be a safety issue and to be too much of a disruption. But then somebody was trying to say, well, that's not a city road, it's a state road. And so is there a way that we can make sure that that is clear, that that they're not using a loophole to say, well, that doesn't count, that Main Street doesn't count?
I'll put a tab and verify. My understanding is that the city has the authority to police all of the roads within the city limits. So I frankly don't know why the city wouldn't have the ability to, if the city can close that road, certainly the city can police the road if it's within the city limits, and I assume the city can close that road. I'll look into that. I don't know why that would work any differently. Just like a county road, a DOT road, city has control over those.
I made the same argument.
Yeah, and well,
But they were trying to say, well, it's not a city maintained road, it's a state maintained road. I said, I don't care, it's in the city limits of
Right.
Graham. And it clearly was the reason why that section was in there because of, and it all goes back to safety, honestly. We don't mind anyone doing any kind of demonstration in Graham, but we need to make sure that all participants are safe
and
at the end of the day.
And that's what this ordinance is getting at, what the prior ordinance was getting at. And what I think this very clearly lays out is just objective factors. That road is within the city limits and it has a sufficient traffic count where it poses a danger to public safety, or it's too inconvenient for the size of the event. That's not a perfect way of saying it. But the city just needs to be able to look at some objective factors and say it's approved or denied on these bases. And that needs to be clear to the public. And that's what I tried to write into this.
I have one question. Under the sound magnification and sound permit, does that include ministers who get on the sidewalks and actually
Preach.
yes,
So sound magnification, yes. If you're using a sound magnification device, you have to comply with this. If you're sitting on the sidewalk shouting, either preaching or otherwise, you're just subject to the city's general noise ordinance. And actually the the language that I used here for the volume restrictions matches the city noise ordinance, which I believe is 12-9. I'd have to check my notes on that, but I looked at that earlier today. So it all matches up. Anybody who wants to use sound magnification has to get a permit if it's going to be audible at 60 decibels measured from 50 feet away, which, for the sake of completing the conversation, I've already talked to Assistant Chief King and Chief Baker and verified that's how the police department was measuring sound anyways. They use a decibel meter. I don't know what the exact word is, but that's, the city's already doing this.
Okay.
We now just have a standard for it.
Um,
And we're not going to be able to adopt any of this tonight.
Right, yeah, and I've discussed that with council, there's criminal implications to this. Obviously, it has to be approved at the second meeting, and that's why I think it's actually great that we get to have this conversation first, and then I can bring back the revisions at the next meeting. None of these really implicate the criminal components of the ordinance. But I'll certainly take a look at these and I can revise accordingly. We've covered what I think and what I anticipated were kind of I won't call them sticking points, but the major revisions to the ordinance. I'd be happy to go through. I started at 171 and then we went to where people wanted to look. You all have a copy of it. I'm happy to walk through and make your eyes glaze over and put you to sleep if you need, but unless you have any other questions, I'm satisfied that we've kind of defended this.
20-1 20-180,
Yes, ma'am.
section B.
Yep.
I'm sorry, section C now. It used to be B.
I had a case for section B, so I was kind of excited.
You had a what?
I had a case on point. That's the language of section B, so I was kind of
Oh,
excited.
I'm sorry about
It's
that.
okay.
Sorry to disappoint.
I'll tell somebody else about it.
Um,
The sign standards.
so right, so there was some wording at one point that said that you could not communicate threats, contain fighting words, encourage someone to hit you, contain slander,
Yeah, so
threats of violence or threats of law breaking.
you are correct, and I'll get the exact language for you. I have the original here.
Think obscenity.
Yeah, the subsection B or 20-180 subsection B used to say protesters may carry handheld written or printed placards or signs not exceeding 36 inches, provided the words used would not tend to incite violence, communicate threats, contain fighting words, encouraging someone to hit you, contain slander, obscenity, threats of violence, or threats of law breaking. What this new section does is square the categories of not protected speech set out by the Supreme Court with the language of the ordinance. Fighting words or it tends to incite violence as an incitement. There's terms of art with all of that, and I tried to use the Supreme Court shorthand here to make it more understandable and also kind of right around right based on what those not protected or unprotected categories are. Slander is not, it is protected First Amendment speech. Obviously, context is always important, but if I said the F word in here, that's not a crime.
Right.
And that's what was kind of revised there. Getting around moving through those protected categories of speech and eliminating those in favor of what the Supreme Court has approved as unprotected categories of speech.
And in regards to B, there's residences that are in the downtown with businesses, it's a multi-use thing. Explain to how that is effective.
It's basically you can't convene and demonstrate before and about the residence of an individual, and that's directing the speech towards that individual without their permission. So if you can't all convene in front of my house and demonstrate or protest against what I've written in this ordinance under this section because it protects this well-being and safety of my home. That's the counterbalancing interest here. The case on point is that they usually deal with doctors or legislators, other political figures that people disagree with, and limitations on people's ability to disrupt their home life and create difficulty for them. The mixed use districts are a part of that. You know, it kind of complicates things because you have demonstrations moving through or permitted in those areas. But that's just one of the considerations that goes into both approving the permit and approving maybe a road closure permit as well. They can't stop and just sit on somebody's lawn without the permission.
So can they go up to a business and patrons are sitting inside that have nothing to do with anything and then start beating on the windows and like antagonizing the people that are sitting there trying to just have dinner or whatever?
It would be disruptive to it sounds like we're talking about private property. So no, you don't have a right to protest on private property.
Well, they're on the sidewalks.
So on the sidewalks, you do have a right to protest, but that right is not 100% superior to the rights of business owners, the rights of individuals in the area not to listen to that person speaking. That goes into complying with the standards of conduct for demonstrations, which would be in this section. Let's see if I can find it. If not, it would be a violation of the terms of the protest because it threatens the public health, safety, and welfare. So part of Chief Baker's review process for approving a demonstration permit, I don't know if that's actually that language that I was discussing is actually in here, but it would go against the terms that the demonstration permit was approved under if you have a demonstration permit. And otherwise it could just be disturbing the peace. I mean, that's writing in those examples is kind of a dangerous game.
And
It is unlawful to interfere with use of speech. It's
Thank you.
unlawful. Graffiti, paint, damage, threaten, damage to, or deface private property.
Correct. And then subsection I is unlawful to interfere with the use or enjoyment of public spaces that have been lawfully, it's related. Public spaces that have been lawfully reserved for purposes unrelated to the demonstration activity. And the other side of it is just general criminal laws. These are working within the criminal law, disturbing the peace or, disrupting a business. That's all still enforceable. This is just regulating how the speech occurs.
And the closure of all the streets are within the sole discretion of the city council. Is that correct?
No, because of the way you phrase that. It's not a discretionary decision. It's based on the objective factors listed in the ordinance, but it is
Yeah.
within the city council's sole authority.
Right, I'm just saying that it's not a staff decision.
That's correct. Yeah, I just
That's
wanted
all
to
I
make sure
have.
that that was clear
Yeah.
because we have public here, you and I could speak colloquially about it, but I want to make sure that's
Yeah.
clear that it's not a discretionary decision. It's based on the objective factors in the ordinance.
No, I know that. I was concerned about the 3-day thing, so we got to figure out how we can.
Reconcile that. Yeah. Expanding that period. It certainly can be done. I haven't found a case, and I've looked a lot, specifically dealing with road closure permits, but they treat road closure and all kinds of, demonstration regulating activity under the same umbrella. And there are cities with, I looked at Raleigh specifically. Raleigh doesn't have a permit requirement for a demonstration. They have a 36-hour notice requirement, which is half of what Graham has. But Raleigh also has much different resources than Graham. With respect to road closure, it's always a matter of how fast the city can gather its resources and how long it takes the city to gather its resources and whether that poses an undue burden on speech. And 7 days, I think, is very safely within does not unduly burden speech. But if you all say that literally cannot be done, then that's another component of it, is that the city needs to be able to administer this and make sure that it gets, doled out or handled with the public safely and without any rush decisions. So that's something that I could take under advisement and that the city could note either on a transcript of this meeting or something like that, or the notes that come from the meeting as to how the decision was made about that period. That's how we came to the 100-person threshold, consulting with the police and fire chiefs. Certainly the same could be done for these notice periods.
In the previous version, it did have a section that said the public right of way, if the public right of way is reserved by another person, organization, by a permit for a special event or community event, they're not going to allow it to be reserved by two people.
First come, first serve, yes.
Yeah. So is that
Yep.
something that, okay, we do, okay.
Yeah, I'll pull that up because that is an important point, and sometimes these things come out kind of wordy, so maybe they're a little bit difficult to understand as straightforward as I might think the statute is, or the ordinance is. But I think it's 20-183C would probably be where that falls. I'd have to read through it. But a first come, first served system is what we were going for here.
And it's what section?
I think it's 20-183C. That's where I would have put it.
Let's see. Okay.
Yeah, but it's 20-183C subparagraph 1, the timing of the event and whether permit applications for events have already been submitted for the same date, time, and location that do not reasonably permit the additional occupancy of the later in time applicant's desired event if the earlier applicant's application is approved.
Okay, and then one other thing that came up, and where I was talking about someone banging on the windows and all that kind of stuff. Restaurant, there's an Asian restaurant on Court Square, and they have a encroachment to use the right of way, use the sidewalk out front of their business for dining patrons. And so people are out there dining, and then there's obviously a demonstration going on, and there was altercations of those individuals that were in the demonstration basically saying, well, I'm on the sidewalk, I can.
So
Hmm.
that's a consideration under 20-183C6, whether the event would be likely to adversely disrupt or interfere with the rights of owners and occupiers of property abutting those portions of the street sought to be closed, or having a right of ingress and egress from their own property to the portions of the street sought to be closed. Those people on the sidewalk would be part of the property owner's right to use that space, which, if granted beforehand, would be, at least as far as possession goes, as far as who can occupy that space, would be superior. I can't apply for a permit to occupy that sidewalk just so they get their tables out of the sidewalk, right? But you still have to consider the other side of that, which is the free speech rights of people in the area. So, you can't interfere with the business, but you also can't make people be silent around.
Yeah, I
sidewalk.
think they were trying to offer the option of doing the courthouse and being in that courthouse sidewalk area, because that wasn't going to be disruptive to any businesses.
Yep.
But
So that's, it's, some of this is a
not that they weren't trying
negotiation.
to offer an alternative, it was just like, there was, a lot of, sometimes people didn't want to necessarily follow what the police were trying to guide them to do to try to keep public safety. So it's like, how do you make people comply with what the police officer's telling them to do? And they're doing it for their own safety, the safety of the patrons, the safety of the public at large, the safety of the demonstrators. So that's just, it's a real world kind of concern.
Yeah, that's it. And the ordinance was written well, with the public safety in mind, protecting those people who have a right not to listen or have a right to kind of go about their business without being severely disturbed. But there's not a whole lot you can do if people aren't willing to follow the law, which isn't exactly what we were getting at. But if if an officer is lawfully and properly giving an order to move on because somebody's creating a public disturbance or violating a protest permit, and that person doesn't listen, I mean, I can't write an ordinance to make them follow it. If that, it's a kind of a crass way of saying that, I apologize, but it's, it's difficult to predict and actually deal with those things. You're right that it's a real world concern. It's just not something that you can write into an ordinance, I think.
And then, so if you have a situation where the driver of a motor vehicle is going around and around and around, with a sound amplification or blowing horn or using a blowhorn or whatever, that we could just, apply our regular, disturbing the peace kind of ordinances and sound amplification ordinance, right?
Yeah, none of this overrides the criminal
Yeah.
law, traffic law,
Right.
anything like that.
Okay,
All of that is still enforceable. This works around it and just regulates the time, place, and manner of people attending these events to make sure they proceed safely.
okay. Joey, do you have any other questions?
No, ma'am.
Ricky, do you have any
Ma'am.
questions? Bobby? Bonnie?
Oh, ma'am.
Do you have any questions of us?
I don't think so.
All right, so, yes, sir. The,
Madam Mayor, the point Judge mentioned several times does concern me from the compliance with the open meetings law. As you have alluded to, there is a 2-day requirement for notice for having a city council meeting. So the question is whether this structure of this new ordinance is de facto taking the granting of the permit away from the city council and giving it to that little special events committee. Because if you don't allow sufficient time to give 2 days notice for having a public meeting, and the attorney here is saying you cannot file within 4 days, even on a weekend, then you're basically delegating to a special events committee and not having the city council be in charge.
well, we're not doing that.
If I may,
But,
Special Events Committee has no authority to close the street. That is solely with the city council. So your point is well taken, and was addressed in part for things that we are going to look at, expanding that 7-day notice window so a meeting can be properly noticed. But the Special Events Committee can't go in and usurp that power, doesn't have the authority to under the ordinance.
All right. And Madam Mayor, y'all gone over it again, 2183 C, and then there are 6 items. And my question is, must all 6 be met, or can the council decline the permit? Must all 6 be met?
Within 3 days of receiving a properly completed road closure permit application, the city council shall review and absent grounds to deny the application as specified in this subsection, issue the road closure permit signed by a member of the city council. So all 6 must be met. You must have your application in order.
that 20-183,
Yes, ma'am.
C.
And I read from the body of paragraph C, and this gentleman, my name is Christian, by the way, I don't think we've met, was referring to the 6 objective criteria that the city council can deny a permit based on. So I guess if you haven't met one, the city council is not obligated to deny the permit, because the language is written, so the city council has to approve the permit if none of these are present. Strictly speaking, if you're, lawyering around the language, the city council could find one to be sufficiently met or find that one of these factors does not need to be met for some reason. But these are the only grounds for which a permit can be denied. It's all about approving the permit as opposed to telling the city council it's absolutely denied if this is not met. So I guess it's proving a negative to a certain extent. It basically, the ordinance is written so the city council has to find one of these if it's going to deny a permit.
yeah, like we said earlier, I mean, I'm sorry I misspoke earlier, but what I would say is that it seemed like all the rules were for everybody else, but then seemed like it was the opposite of what people might necessarily think is that, at least I feel that this council, overly, made sure in every way that we were protecting people's right to free speech and First Amendment privileges. And when certain people have said, made criticisms, I'm like, name another city in Alamance County that had 48 protests in 52 weeks.
Sure.
I mean, we very much uphold the Constitution, and we want people to be able to have the right to speak on their grievances. But along the same lines, we have to have certain things in place to ensure the safety of everybody that participates, including our staff, and including the participants. So, when I say that we have the discretion within these guidelines of this ordinance to be able to make decisions on road closures, and paramount to that's going to be safety.
Yeah, so maybe we were looking at it different ways, and that's why I felt the need to correct you or talk about it a different way. You do have discretion, I suppose, to waive one of these requirements. The way the ordinance is written is really just to ensure that, let's say I'm applying for a permit. I know I'm right up against the timeline, so I'm invited to your meeting and I forgot to put the start time of the event for whatever reason. You could deny my application because it's not on the sheet of paper what the start time is, but you could also waive that because you've given me the opportunity to cure it, and I've told you that it's going to start at this time. Now, given the opportunity to cure is, again, a dangerous game because of how that gets enforced. But practically speaking, this is just about how the city council can deny permits. Otherwise, if these aren't present, they have to be approved. Those are the rules. That's it. Whether the city council waives one of these is beyond me.
It just seems like the rules applied to everybody else that was trying to get a permit, except for, and then there's certain people that want to come and they haven't prepared adequately and they haven't done any of those things. And they're like, you're just trying to keep me from being able to do this. And that is absolutely not true. It seems like all of the rules were being followed by other people, but some people just don't want to have any kind of, and the rules are in place not to keep people from doing things. There's just things that happen all the time, events that happen all the time. It's just really to try to make sure that we don't have people walking out in the street with 20,000 cars.
Sure, and part of that could be intentional. It could also be an inability to understand or difficulty understanding the process itself. And that's kind of what I'm hoping this revision will do is
Very clear.
for the person who is looking to comply, it is very clear to that person what they need to do to get the permit that they want. If you get the person who, if I come in here and say, I want to close a road and I don't have any of the information you're asking for, and you deny that permit and I file a lawsuit, there's nothing you can do about that. And that's a very extreme scenario and certainly not one that the city has faced, but there's a certain degree of, you need to be prepared to follow the law when you're going to organize one of these events. And I think that's, you have to be pretty organized to have a 1,000-person event and close a street. It's certainly not we're not trying to weed people out by any means, but it's, the city has to have its guidelines. And if you deny permits based on these objective guidelines, I think you're safe.
Madam Mayor, is it not also possible city council members, 5 members, may divide on, let's just take as example, C2 or 6, that in other words, a majority of the council may feel that one of those is not being met. Other members of the council may feel that it is, but in other words, it's not necessarily an objective. I mean, I know it was stated as an objective matter, but I think the individual council members might conclude that it's not, does not meet number 2, for example, that it's going to inhibit the flow of traffic, threaten public safety, or in number 6, that it's going to adversely disrupt or interfere with the rights of owners and occupiers of property. These are things on which the council members might well disagree.
Majority rules.
Second.
They might, majority will rule.
Right. Well, but it seems to me, when the attorney is speaking, I'm not sure that you get to do that. I mean, can you have a disagreement among the council on one of those 6 items? One or more of those 6 items?
Madam Mayor, what I'm hearing here is addressed in Thomas versus Chicago Park District with respect to a demonstration permit application. And I will add a little bit of language that won't really materially affect how this is practically implemented. But I drew these provisions from that case. And I'll make sure that the language matches so they are deemed objective factors. There's I guess a subjective component to anything. Reasonable minds can differ. What we've designed here is a system where the reasonable minds have to look at the facts and they have to make a decision. You know, at a certain point, it's difficult to govern. I'll revise slightly according to the commentary we've received for sections 2 and 6, and I don't think that it's going to have a material impact, but I hear the criticism and think it's well-intentioned.
Lastly, Madam Mayor, if I may, on a different topic, and I'm not sure that it's in this ordinance, but it's been alluded to several times. I think the phrase is a free speech area. What is the name of the area here in front of City Hall?
Yes.
And Madam Mayor, I think you were the one who made reference to the problem that has certainly occurred in the past where loud protests on this side directly in front of the council chambers have been disrupted. Is it not possible to redefine the free speech area to be only the other side of City Hall when the council is in session? In other words, attorney, there's a sidewalk that splits the front area pretty evenly. This side is obviously in front of the council chamber. The other side is in front of offices that nobody will be in tonight or at the time the council typically is meeting at 6 o'clock at night. Would it not be possible to redefine the area so that you don't have the squabble about people directly in front of your chambers during a council meeting?
I think that gets to the reasonableness of a time, place, and manner restriction. The city's not required to open up a public forum, but once it designates a public forum, the public's free speech rights are at their strongest in that area, just like the streets and sidewalks and parks. You can impose reasonable time, place, and manner restrictions on those designated and traditional public fora. The issue you run into is whether the restriction is reasonable and whether there are adequate alternative channels of communication. Because once the forum is open, it's open and you have to treat it like a traditional public forum. If the city wanted to do away with it, it certainly could. That may, that would kind of change the analysis for the rest of the ordinance.
We were never trying to deny the particular person. In fact, I think they had signed up to speak, but it's difficult to hear you speak if you're here on someone's on the other side of this door with a megaphone amplifying sound. And just as we want to respect that person when they come up to speak and not allow other people in the room to speak, the same goes vice versa. Developer was here, I think, trying to present his presentation. It was really difficult to hear him, and it was difficult for him to hear us when it's disrupting the meeting. We do not have a problem with someone voicing their grievances, but at some point it becomes disruptive, and I think the General Assembly has had quite a few issues with
I'm
this
sure.
as well.
Yeah.
So we could just look at the case law and
Yeah.
figure out if we can come up with a reasonable and lawful addressing of that. That would be great.
I will do that.
Okay, thank you so much.
Madam
So this is, okay, go ahead.
Madam Mayor, I make a motion that we schedule the second reading
at our next meeting.
Yep, we don't, this isn't a public hearing, so we don't have to close the meeting, but there's a motion on the table to schedule the second reading of the ordinance. Do I hear a second?
Second.
All in favor? All opposed? Motion carries.
Madam Mayor, will there be a public hearing in connection with that or at any point?
Have a public hearing tied to it. It's not in our development ordinance.
And was there anybody that signed up in the back, officer? Okay. Bob, you got anything? Anything, Brian? Aaron?
I'm not gonna drag this on, but I would like for y'all to check your calendars. If you would, we're gonna need to schedule a special meeting. We could probably do it at 12 o'clock or something like that. It won't take but a minute or two. It really won't. There's grant money for us to be able to go after with the state for some funds to address some emerging contaminants that are on the horizon. I know y'all heard about the PFAS stuff that's out there. It's gonna affect us as well, so we need to make sure that we address the criteria for that study. If you could just check your calendars over the next week or so, see if you have any availability for a 5-minute or less meeting to approve a resolution so that we can go after that grant money. That would be great.
Next week, I'm clear next week, bro.
Perfect. So I touch base with everybody.
On me.
Okay, got two. All right,
I have to check my calendar, I'm sorry.
no problem. I didn't want to put anybody on the spot.
Oh, actually, I have my calendar.
Are we talking about noontime meeting?
Probably so. And it literally won't take but a minute, to be honest with
I don't have anything next week, I'm fine.
Yeah, if it's around noon, I'm fine.
you. Maybe Wednesday, I won't be here Monday. Will Wednesday be okay?
Wednesday at noon?
So I don't know. I haven't checked Megan's.
15th.
That reminder for Wednesday.
I'm
Yeah.
thinking that.
Thank you.
All right.
Said Wednesday, right? All right, oh, you have anything?
No.
Joey,
No, ma'am.
Ricky? You have anything, Madam Clerk?
I do.
I'm
um,
busy.
The appearance board requested back in April to raise their budget to $1,500 so that they could do the fall decorations. And I would like for us to vote on an amendment to do that, to raise their budget to $1,500. Somehow it got, I don't know what happened to it, but they do need that money for the decorations this fall. So I was wondering if I could make a motion to do that, to raise the parents board's budget to $1,500.
I don't have I mean, I'm happy to vote in favor of that, but I think we have a rule that we can't like vote on something without it being published or whatever. But is there a way that we can put that, maybe handle that on the meeting next week, since it's just a clearing up of things and we'll be able to give adequate notice?
That's one option, or I think we would be okay with council consensus to allocate a certain dollar amount, if it's 1,500 or some other amount, to be funded specifically for the appearance commission's beautification type initiatives. So if that's something, instead of going the budget amendment route for a $1,500 item, we could just kind of get 5 head nods that say, we are fine with allocating internally funds that have already been approved as a part of the budget process for the Appearance Commission beautification projects.
Can we do that at next Wednesday's meeting, just so that we have a notice? I just don't like doing things the same. I mean, we kind of have like an unwritten rule that we won't do things as it's brought up the same night. I thought it was already in the budget. So if we're gonna make a change, I just don't want to set a precedent that we're changing that.
You can certainly handle it whichever way you want. The option I suggested as the latter alternative didn't involve a budget amendment.
And that's fine, but can we at least say publicly that we're gonna make a decision about that next Wednesday, so that it isn't like that we're doing it at the end of the night and then voting it on at the same time without any public notice?
Yes.
Okay, and it can still be a consensus. We don't have to necessarily do a budget amendment, but I thought it was it's more of like a clarification of what well, at least what I thought, Bonnie thought, I don't know how other many council members, I thought it was, certainly was discussed, and I didn't sit there and read through again the budget, but I thought we had all agreed on it. So if it's just, if it's an oversight, it's fine, I think. So is that okay, Bonnie?
Yeah.
Okay, all right, and then, had a great balloon festival this past weekend. Know it rained a little bit, but just want to personally thank, Bobby Chin for all his hard work, and Chuck for all his hard work. There was a lot, Richard Shevlin, there was a lot of volunteers out there. Appreciated all that you guys did to make that event happen for Alamance County. It was very nice. And Joey Parson, I mean, wonderful, wonderful people doing a lot of good things for the community. We greatly appreciate it. So that's all I had to say about that. We have a concert coming up this Thursday. Remember who the band is?
The Magnificence.
The Magnificence will be, is that the Thursdays at 7 or the?
Thursday at
Okay.
7.
And then what is the Ken Folk concert? I want to say it's Mason Lovett. I could be wrong.
No, it's not Mason Lovett.
Who is
I
that?
think it's the Backstreet.
Orchestra? Backstreet Orchestra.
Backstreet Boys.
No, Backstreet Orchestra. So you can check those out online at visitgrahamnc.com and see what concert bands are coming, but they are coming up. And we still have our paddle tours that are going on, I think, at the Graham Mebane Lake, which have been a big hit as well.
There's also a movie at the
Movies at the
Cook,
park. Mhm, Bill Cook
7:30
Park.
Saturday.
So can I get a motion to adjourn?
Madam Mayor, make a motion to adjourn.
I have a second.
Second.
All in favor?